Good morning, Your Lordships. My name is Natasha Matilda Phillips, and I'm here on behalf of the Law Commission to argue why it is now time for the English law to embrace a duty of good faith in the performance of all contracts. I will specifically discuss why it is now time for the common law to adopt a conciliatory approach where the intention to gain goodwill will in turn reduce hostility and minimize legal disputes without prejudicing or altering the parties' legal rights, and how this is an advantage that should be welcomed rather than disregarded. I will be highlighting the case of Yem Seng v. ITC, more explicitly Lord Legatt's obiter, where he famously noted that in not having a notion of good faith, English law was swimming against the tide. To begin, I would like to outline what the duty of good faith is. Essentially, to act in good faith means to act in the spirit of the contract and in line with reasonable expectations of the other party. This includes acting fairly and not taking unfair advantages of the other party through acting in accordance with the common purpose as agreed by both parties. To put it simply, drawing from the recent decision made in D&G Cars v Essex Police Authority, Dove J stated that he uses the word integrity in the same way where Lord Legatt had used the phrase good faith in Yem Seng. Therefore, reinforcing again that the act of good faith is purely to seek to create an environment where disputes and claims are resolved with the utmost consideration whilst helping to preserve commercial relationships between both parties. However, as your lordships know, there's currently no general doctrine of good faith under the English law. Good faith clauses are commonly found in commercial contracts but can be often overlooked. This is because English law promotes individualism that enables each party to pursue its own interests, and therefore good faith is applied only where there is an express obligation in a contract to do so. As well as that, English law places great weight on contractual certainty, and an implied duty of good faith is presumed to undermine this principle, particularly because deciding what the actual obligation entails can be vague and subjective. But this is exactly why, in Yem Seng, Lord Justice Legatt emphasizes that the context of the duty to perform a contract in good faith is dependent on context, and drew out two aspects of good faith, first being honesty and the second, fidelity to the party's bargain. I'll expand more on this in the following slides. The case of Yem Seng v ITC is a captivating one that really raises the debate surrounding the need of good faith in contracts. Both parties entered a written contract entitled Manchester United Distribution Agreement, where the defendant ITC granted Yem Seng the exclusive rights to distribute certain fragrances bearing the brand name Manchester United in specific territories in the Middle East, Asia, Africa, and Australasia. Yem Seng is a company incorporated in Singapore, which is controlled by Mr. Sunli Tully, and ITC is an English company controlled by Mr. Roy Presswell. The business relationship between the two companies were warm, along with sharing a close relationship between the two individuals. Therefore, when ITC was faced with claims for damages for an alleged breach of the agreement regarding late shipment orders, failing and/or refusal to supply all the specified products, undercutting prices agreed, and for providing false information, their business dealings soured, and along with that, their internal personal relationship as well. Understandably, when Mr. Presswell's business relationship with Mr. Tully broke down, Mr. Presswell felt angry and outraged at what he regarded to be unwarranted attacks on his integrity. It was pleaded in the particulars of claim that in Yem Seng's case, there was an implied term of the agreement that the parties would deal with each other in good faith. Lord Justice Bingham, in the case of Interphoto Picture Library v Stiletto Visual Programs, observed that the English law has committed itself to offering solutions for specific problems, rather than by enforcing broad overarching principles. This is again because of English law's fixation on being the ethos of individualism, where it goes contrary to the idea of freedom of contract, whereby parties are free to pursue their own self-interest. So why interfere where the parties have freely negotiated their terms? As recognized in modern case law on construction of contracts, contracts are formed through unstated shared understandings that include not only matters of fact known to the parties, but also shared values that include an expectation of honesty. These are also taken for granted because they are not expressly set out in the contract. In the 2009 case of Attorney General for Belize Telecom, Lord Hoffman commented that there are standards to commercial dealings that are generally accepted where both parties would be expected to understand without stating them in the contract. However, drawing back on what I have stated earlier in the presentation, Lord Justice Legatt's emphasis on consideration in the performance of good faith relies on two core principles: honesty and fidelity to the parties' bargain. To demonstrate fidelity is to show loyalty and a commitment to each other's terms, and a breach of this can result in the loss of mutual trust and the falling out of two businesses. Again, depicting the importance of outlining and negotiating the expected standard in the event of a breach or failure of meeting a specific term in the agreement. Regardless, your lordships, I will remain realistic and state that contracts can never be prepared for every single eventuality. But I will reinstate and argue that good faith maintains the value of integrity. Whilst Mr. Presswell was being accused of breaching the terms within the contract, he was angry. He felt his integrity was being questioned. Through incorporating good faith into the performance of all contracts, it would eliminate the problem of hostile behavior against both parties and would lead to both individuals more than likely maintaining their business relationship because there was a well-discussed and planned notion of good faith negotiations prior to the agreement of the final contract. This brings me to my next point. Why do we need good faith in the beginning? As touched upon by the British Institute of International and Comparative Law in their Concept Note 3, they have proposed a set of practical guidelines aimed to encourage a more conciliatory approach to contractual disputes that do not aim to seek or modify the parties' existing legal rights or obligation, but rather to encourage parties to take practical steps to promote the efficient resolution of disputes that will benefit the wider public interest. Using the guidelines recommended in the concept note, we can encourage the implementation of the general duties of good faith into commercial contracts. Because these guidelines are aimed at finding an efficient resolution to disputes, all claims will be examined in the most appropriate manner where the goal is to reach a settlement without the need to pursue legal proceedings. To deal with someone in good faith means to also be transparent and open to negotiations when a disagreement arises. The note suggests parties should adopt a non-prejudicial cards on the table approach, where information is shared that is beneficial to the continued performance of the contract, along with engaging in discussions to explore solutions to balance the impact between all parties. Parties can look into using alternative dispute resolution, otherwise known as ADR, such as mediation, where concerns are dealt with in a neutral setting outside the courts and is overseen by an impartial third party. A big advantage to this is that it shows that both parties are committed to improving their situation through agreeing to undergo mediation in the first place, which correlates to what good faith is trying to achieve in the first place. Using these alternative methods for dispute resolutions will reduce costs for both parties because situations will be dealt with in private, and as well as that, there is no publicity and thus will not affect the interest of the general wider public. This brings us to the final stage of my presentation, where I'll end by saying that Lord Justice Legate's statement of saying that English law, in not having a notion of good faith, was swimming against the tide, implies that it is now time for English law to consider the importance of implementing a doctrine of good faith to enhance the performance of all contracts. Your Lordships, the world has modernized. The general principle of English law does not always apply in every circumstance. New doctrines are constantly being introduced, and good faith should not be excluded simply because of English law's focus on individualism, but in improving the efficiency of the courts and in maintaining business relationships. Therefore, to conclude everything that I have touched upon, I believe that it is now truly time for English law to embrace the duty of good faith in the performance of all contracts, and I urge the Commission to take my arguments into deep consideration and to see the true benefits of having good faith. I'd like to thank the Commission for your time, for hearing me out and hearing my arguments on why I believe that it is now time for English law to embrace good faith in all contracts. Thank you so much again for your time. If you have any questions or any concerns, please do let me know. And that just about concludes my presentation. Thank you so much again.